Hi, everyone. Welcome to this panel on person-centered justice. My name is Jérémy Boulanger-Bonnelly. I'm an assistant professor at McGill University's Faculty of Law. Very glad to be here. Thank you to the organizers. I'm going to be chairing this panel, moderating the panel. I'm joined today by four, soon five, I don't know if Ab's here. Oh, yeah. I was here, five superstar scholars who are going to talk about various aspects of person-centered justice. So very excited to hear their presentations. Each presentation is going to be 8 minutes long because we are a lot of people on this panel. So I'm going to try to keep track of time. And afterwards, we're going to have a 20-minute question period if all goes well. And so the first presentation is mine. And so my presentation, the paper I'm presenting today, talks about person-centered justice, of course, from a more theoretical perspective, perhaps. So the context of that presentation is, as some of you may know, that person-centered justice has become quite the buzzword in international initiatives around access to justice. Many organizations, including those listed here, have made it really a central pillar of their justice initiative and programming. And so that term is, of course, very popular, but it remains poorly defined. And so the broader project of which this presentation is a part of is to try and find a more precise definition of what that concept of person-centered justice actually means. A part of that conceptual work is to try to compare person-centered justice with other approaches to access to justice that have been burgeoning over the past decades. And so this paper, what I'm trying to do in it is to compare person-centered justice with another concept that has been around for quite a few decades, which is participatory justice. And I'm trying to ask, is person-centered justice bringing something else to the table, something new that's different from participatory justice? And to give you a spoiler alert, the conclusion of my analysis is that these two concepts are actually very, very similar, nearly identical from what I've seen. And so, in my opinion, we have further work to do to try to refine and define a bit more what's new about person-centered justice, if we want it to be more than just a marketing strategy, more than a buzzword, and really have some normative content to it. You may ask, why is that important? Why do we have to talk about concepts and theories? Well, concepts are really fundamental because they're the building blocks of the theories we have about access to justice and the normative direction we want to go in. They can explain phenomena, they can guide us, they can give us a common language among scholars and make sure that we are in the same research stream, that we're not too confused. In some areas, in other disciplines, people have talked about a tendency sometimes in burgeoning fields, such as access to justice, which is concept proliferation. What that means is that sometimes people have a tendency to create new concepts, new words, to designate what is actually something that has been identified as another concept previously. And that raises some issues, including perhaps some confusion and also the development of different research streams, people talking past each other, essentially. And so the question from that angle in my paper is to determine whether person-centered justice is a symptom of concept proliferation. Are we just creating a new word for something that already existed? And in particular, are we just replicating what participatory justice meant? So the first step in that analysis is to look at what person-centered justice is. Last year at the International Access to Justice Forum in Irvine, I presented a paper that was precisely meant to define a bit more what person-centered justice is. And what I did was a reflexive thematic analysis of the existing literature on that concept. And so I tried to identify some of the main themes in that existing literature. So I'm not talking about what person-centered justice could be, but what it is currently described in the literature. The first theme I saw was a focus on empirical data about legal needs. So there's really this empirical component that's emphasized, and I think also in many of the presentations this week. From that empirical data, we see two other themes emerging. The first one, of course, accessibility of legal services. That's nothing new for you. Access to justice is central to person-centered justice, but also the flexibility of legal services to be able to address different needs in different contexts in a more holistic way than traditional legal services. A fourth theme that emerges from that literature is the notion of empowerment. So person-centered justice tries to empower individuals in the resolution of their own disputes and also in the creation of legal services to make them more sustainable over time. And finally, the fifth and sixth themes that I found were these ideas of local justice and community-based justice, which interact with person-centered justice to create, once again, more sustainable legal services. So these six themes, my literature review was until 2023. And in the past year, the literature that has been published around person-centered justice reinforces these themes. They seem to still define what people see as person-centered justice. It may be interesting because of the topic of this presentation to also note that the literature on person-centered justice discusses participation quite a lot. And so to take just one example, the OECD framework published in 2021 says that people-centered justice refers to a justice system that puts people at the center and has as its purpose and its design the goal of equally meeting the needs of all people of that jurisdiction, by enabling their effective participation and engagement in the process. So participation seems to be quite central to person-centered justice as well. And so if we shift now to participatory justice, what it means and how it's been defined in the past, we see that there's the same overarching objective of centering justice on the person. As early as 2003, the Law Commission of Canada published a report on participatory justice, and it said that the participatory justice was about developing new ways of responding to conflict that place the parties to it at the center of the resolution process. And similarly, an author from Quebec, where I'm from, in 2011, he wrote a book on participatory justice and said that the individual is at the center of the perception of access to justice, and that this conception is better adapted to the contemporary needs of litigants, which is also a theme we see in person-centered justice. When we dig further and look at the literature around that concept, we see similar themes identified as characteristic of participatory justice. So accessibility, of course, is a key theme. Participatory justice seeks to make accessible a form of justice perceived as such by the person to whom it is provided. That's from the same Quebec author. Flexibility is also central to participatory justice. So any process or system should be sufficiently flexible to take into account individual needs and goals. That was from the Law Commission report in 2003. Empowerment, of course, that goes without saying, it's connected to participation. It's central to it. And so the same theme appears in that literature. And finally, participatory justice initiatives have been connected with local and community-based justice because one goal is to rebuild relationships through justice in local communities. One potential difference that some people may identify between participatory justice and person-centered justice is the fact that participatory justice has been associated with ADR mechanisms. That's one of the main reforms that has been prompted by participatory justice. But if we go back to the conceptual foundations of participatory justice, these foundations are much broader than just ADR. They emphasize this idea that participation should be central to the way we provide access to justice. And so what is the conclusion of that very short presentation? First, I believe that there is a measure of some concept proliferation when we talk about person-centered justice. The literature doesn't really distinguish what person-centered justice brings to the table that is new in comparison to that other concept of participatory justice. So one solution to that problem would be to just say, well, let's leave person-centered justice aside and focus on what we know already, participatory justice. But maybe that's too radical because organizations and people, as I said earlier, have embraced that concept of person-centered justice, and it has great appeal. And so another solution, and what I propose, is that we perhaps take a bit more time to think about that definition of person-centered justice, what it means from a conceptual standpoint, and try to identify beyond participatory justice what person-centered justice really means, what it brings to the table, and how it's new and how it can lead us in new directions. Otherwise, I fear that we're just going to be rehashing the same concepts and leading to similar reforms over time. And I feel like we have to go into a new direction with that concept. So that opens new avenues for research. And I hope you enjoyed the presentation. My time is up. And so I will jump to the next presentation. Thank you. So our next speaker is Georgina Rychner. One second. So Georgina is a senior researcher at the Victoria Law Foundation, a not-for-profit based in Victoria, Australia. Her research investigates legal need, legal capability, and people-centered justice solutions. Prior to joining the foundation in 2023, she worked at several leading Australian universities, as well as the Victorian Parliamentary Budget Office. The floor is yours.
Thank you, Jérémy. So good afternoon. As Jérémy introduced me, my name is Georgina Rychner and I'm a senior researcher from the Victoria Law Foundation. Today, I'm going to very quickly take you through a research project that I'm co-leading with my colleague, Bridget McAloon, which is titled Measure for Measure, Tailoring Everyday Justice. So by way of background, Victoria Law Foundation's data mapping reports examined how administrative data is collected across the Victorian civil justice system. These reports found that, broadly, data that is currently collected is not enough to tell us what works to effectively meet people's legal needs. More recently, our Public Understanding of Law survey, which was released in 2023, laid the groundwork in revealing legal problem prevalence in Victoria and showed that there are high rates of unmet legal need, even when Victorians accessed legal services. So we call the survey the Pulse. The Pulse highlighted the critical gaps in our empirical understanding of what works to meet legal need. Where the evidence base for legal need is metaphorically thick, the evidence base for what works is comparatively thin. So now our research team is looking to explore what is working well in Victoria for particular clients and communities to meet their legal needs. In searching for a suitable framework from which to approach this enduring question of what works, we turn to the global literature on people-centered justice, which seeks to put people rather than institutions at the heart of justice systems and legal services. So a very high-level definition there. In 2023, the Justice Data Observatory put forward a research brief titled Envisioning a People-Centered Access to Justice Research Agenda. So this research agenda called for three kinds of knowledge: knowledge for inspiring change, knowledge for understanding how people-centered justice matters, and knowledge for implementation. And sadly, I don't have too much time to elaborate more on the former two streams, but our project ties directly into what the JDO called knowledge for implementation of people-centered justice solutions. That is, what interventions work for whom, when, and where? What solutions are effective, and how can they be sustained and scaled up? So our project is the first in a new stream of evaluative research for the Foundation, which aims to make a start in answering these questions through collecting the on-the-ground experience and perceptions of people working within the Victorian civil justice sector. So as this is an exploratory project, we cast our net wide in terms of who we wanted to include. We wanted to hear from our Legal Aid Commission, our community legal centres, of which there are 47 in Victoria with varying sizes and forms, the Victorian arms of Australia's two First Nations legal services, as well as Victorian courts, tribunals and complaints bodies such as the Victorian Ombudsman. So in the first phase, we invited all of the above to take part in a short survey. We invited respondents to put forward what we call an initiative. So this could be a simple intervention, it could be a project or a service that had been running for more than 6 months and had been designed with a specific target client group or legal problem in mind, and that they saw to be working to meet legal need. Our survey took elements from the JDO's research agenda, and we kept survey questions pretty open-ended. We were just as interested in how stakeholders identified legal need, what evidence they used, and how they defined and measured success as we were in the specific targeting toward client groups and problems. We posed open-ended questions such as, what makes the initiative work? And how do you know that the initiative's making a difference for your clients and communities? In the second phase, we used a selection matrix to identify 23 initiatives to follow up with via in-depth face-to-face interviews. And in doing so, we wanted to ensure a good cross-section of client type, problem type, initiative type, geographic location, and size. And these interviews were really an opportunity to further explore key themes of the research, including effectiveness, funding, sustainability, and scalability. So we have just wrapped up interviews and we are about to go into coding and analysis. And the final product of this project will be the final report, which is slated for release in 2025. So watch this space. So I'll just quickly whip through the survey results. We received 66 initiatives from 30 organisations, which was a fantastic response from a sector that is strapped for time and resources. And there was no additional incentive for them to fill out this survey. So we really appreciate it. Of the 66 initiatives, the vast majority were from legal assistance services, including Victoria Legal Aid and community legal centres. We received 5 responses from courts and 4 from other complaints bodies and organisations. So we did have orgs such as legal tech companies who had partnered with Community Legal Submitted, which was great to see. We received initiatives across broad areas of civil, criminal and family law and a range of initiative types. So we had health justice partnerships, education partnerships, community legal education, chatbots, drop-in clinics and self-help resources. And we had really targeted services for specific client groups, which is what we wanted to see. So for example, one community legal centre was assisting sex workers in navigating decriminalisation legislation. And we also had a lot of projects that assisted refugee and migrant women who were at risk of or were experiencing family violence. And in terms of geography, we received 11% of our responses were from rural regional areas, which was also fantastic. So I'll very quickly try to whip through some preliminary findings. I think I've got about 3 minutes. We have not, just as a disclaimer, we have not interrogated any available evidence of effectiveness because data continues to be a challenge in this sector for various reasons. And so we can't prove that these initiatives are working or working better than other initiatives or regular service delivery. This is a potential avenue for further research after this project and one that we very much want to explore. However, there is value in hearing from those that are working on the front lines as to what they see as working effectively. And in doing so, we have identified common elements that are likely to lead to successful or at least promising person-centered initiatives that go some way to meeting people's legal needs. So we've pulled these elements into an iterative model that will likely evolve as we undertake in-depth coding. We know that a lot of these elements are not new and they might have actually come under previous concepts, such as you discussed, Jérémy. But it is interesting that many initiatives that are running and seen as successful in Victoria demonstrate most, if not all of these elements to some degree. So just very quickly, targeted, they have a clear idea of what cohort or problem type the service is for, and this is clearly evidenced and factored into the design and often factored into the data collection and the monitoring. Accessible and timely gateways. So this means practical and better pathways into the service that are user-friendly, including, for example, strong referral networks, outreach and co-location with non-legal services. Responsive, this refers to providing proportionate services. So there needs to be an ability to ramp the level of service up or down according to each individual's legal needs and capability. And this is often based on the lawyer's discretion, not a formal triage tool, although those are being explored as well. And it's a recognition that different clients will require different levels of intensity and building that flexibility into the service. Use of data, evidence and learnings, so both in design and in implementation, where findings are consistently fed back into the project to improve it. And this includes reviewing what data they might be missing out on. So do they know who might be missing out on the legal service? Leadership and an enabling environment. So there needs to be permission from the top to trial new approaches in this sector. And it's also important, it's important to note the individual leadership being shown by those running the project and the importance of passionate and skilled people to this work. And finally, a collaborative and coordinated approach. So this goes to building strong partner and referral relationships, trust, with partner organisations and within communities was often emphasised as being crucial to bringing people into the legal services. And part of this element was building capability of other sectors with a view to supporting pathways to legal help. So we actually heard a lot about the role of what we are calling intermediaries. These are individuals that serve as a link between help seekers and legal services, and they ranged from health practitioners, teachers, and social workers to family members. And we've already heard quite a bit about intermediaries or legal navigators in the previous panel. And we weren't fishing for this in our survey. We did not ask anything about intermediaries, but this is what was coming to us through the survey responses, which was amazing to see. So many initiatives focused on building the legal capability of intermediaries. And when this was done well, intermediaries felt confident in identifying the legal problems of, for example, patients or their students and referring them into legal services beyond the lifetime of that specific project. So this work needs to be recognised more by funding bodies as a sustainable means to meet legal need. I have already come to time, so apologies, but stay tuned for the final report. There's a lot more to this, and Bridget and I look forward to presenting at future conferences on this work. Thank you.
Thank you. I feel really bad. Oh, that doesn't work. I feel really bad stopping that because it's so interesting. So the next person to speak is Nicki Lees. So Nicki is a special counsel in the social justice practice at Morris Blackburn Lawyers. In this role, she has run and led strategic human rights litigation for over 8 years. She's been involved in Exhibit AI, an account of daily life on Manus Island and Nauru, which I believe will be the focus of the presentation. So the floor is yours.
Thanks, Jeremy, and hi everyone. It's a pleasure to be here today with you. So I was just introduced. I am a special counsel at Morris Blackburn Lawyers. We're a law firm in Melbourne, Australia. I work in what we call the social justice practice. So it's basically the human rights litigation, doing pro bono work often. I'm joined by my colleague, Jennifer Canis here, and I'm going to talk to you today about a project we're really proud of that we worked on together called Exhibit AI. So in short, Exhibit AI is a project where we published AI-generated images of court documents and witness testimony from a case that we were running. And this was all court documents and witness statements from refugees and people seeking asylum in Australia. So I'll give a really brief overview in this 8-minute presentation of how we used AI to tell client stories and how the feedback was that this really contributed to a sense of restorative justice and how we focused the refugees at the centre of this project. So just a quick trigger warning, I am going to show you some photos from the project that does depict physical abuse in some of those photos. So please feel free to leave or take care of yourself however you need to. So a really quick background to the issue. For those not from Australia in the room, Australia since 2017 has had a horrendous policy of sending people that seek asylum by boat to tiny islands in the Pacific, and that's to Nauru and to Manus Island. So to give you a sense, Nauru is 5 kilometres by 4 kilometres. You can walk around it in a couple of hours, and people are there for over 10 years at a time. Importantly for this project, journalists and photographs were banned. They actually passed a law saying it was illegal to take any images of what happened in the detention centres. And scores of human rights abuses, the stories of human rights abuses were coming out of those detention centres, but no images could be shared. So we ran a class action that went for 5 years, challenging the legality of these centres. A decision in another case meant that our case had to be withdrawn a couple of months before trial. Now, we had spent over 300 hours taking witness statements from over 80 people who were detained on Nauru and Manus, and we basically created the largest collection of evidence of day-to-day life or first-hand witness accounts of what happened in those detention centres. And when you finish a case, the strategy is that everything just goes into archiving and then it's destroyed after 7 years. So basically, when we had to make those heartbreaking calls to the clients saying, thank you for sharing your story, but we had to withdraw the case, they all said to us, that can't be the end of our search for justice. Can you please work with us to find another way to share our stories? So we created a working group or an advisory group of 10 of those refugees and how they wanted their stories shared and how they felt like they could have still achieved justice, even though the court system had essentially let them down. So the advisory group was really clear in how they wanted to do that, and that was through using images. So in the words of one working group member, they told me that images transcend language, cultural, and social differences, and that's how we want justice in this case. So in partnership with a creative agency, we decided to try using generative AI in this context. So in partnership with the refugees themselves and the working group, we came up with 3 clear aims for the project. 1, to use these images to actually educate the global public, the Australian public, on what was going on in Nauru and Manus. 2, to provide a physical product that we can take to people in Canberra, our capital, to try to stop this issue from occurring in the future. And 3, to get that sense of restorative justice for the people who are involved. So to create the images that I'm about to show you, sections of the court documents were run through the program Midjourney. If people have come across Midjourney, it was quite a new technology when we first started doing this. And these prompts formed the images that I'm about to show you. So if they felt comfortable, and it was a completely voluntary process, participants provided feedback on the image. So sometimes it took weeks and weeks and weeks of back and forth with the refugee in question, where they said, oh, actually the tents didn't look like that, or there was more mold in the tents, which you'll see in a second. And it was that real collaborative process around how do you want this image to represent your experience on Nauru or Manus. Cool. Oh, thanks. So look, I'm just going to flick through some of the images as I talk, but you get a sense of some of the prompts or parts of the court documents or witness testimony that we used to create the images. And that image on the screen took weeks of working with one of the refugees to get the level of mold, the colour of the tent, the state of the curtains, if you can call them that. So it gives you a sense of what the end product was. So the project was distributed widely and went much further than we thought it would. We held an exhibition in Melbourne. We had an exhibition, a small exhibition at Parliament House. We created a physical book that we gave to over 10 different policymakers and members of Parliament, created a website, and there was really good international and domestic media pickup. So our media monitoring shows that we reached almost 10 million people in Australia alone with this project, with a population of almost just over 25 million. And it was really obvious that without the use of AI images, our clients' stories wouldn't have travelled so widely. But look, this was an emerging technology, and there were really important ethical questions to navigate when we developed it. So we wanted the images to show a true reality that couldn't be shown in other images, but we didn't want them to be mistaken for photographs in themselves. And there was also, I guess, at the centre of the project, a real recognition of the trauma that these people had been through. And this was not an easy project for them to be involved in. And so we were led at every step of the way of what they were comfortable with. Often I'd call them up and describe the image before I sent it to them, and they would say yes or no if they wanted to see it or not. We also had psychologists on hand if we needed. However, the overwhelming feedback was that the creation of these images played a really important role in participants feeling like they achieved a sense of justice and healing. To quote one of the refugees, they said, "I wanted not just the Australian people, but people all over the world to know what we went through. After 5 years, I still have frequent nightmares that I'm on Nauru. I wanted to be involved in this project because I hope from the bottom of my heart this doesn't happen to any other human." Some of these are a bit more graphic, so I'll just flick through them. So recently, an individual at Oxford University did a paper on Exhibit AI. And following interviews with participants of the project, he concluded that he found evidence that using generative AI helped at least some former detainees navigate their experiences. One individual in this research paper told him, "It makes me so proud that I've been part of this process of actually showing people what happened on Nauru. And I'm so proud every time I look at this book. I keep it next to me in my bedroom, and while I can't look at it too much, it's part of who I am. Every time I feel like giving up on my situation now, I look at this book and it makes me feel strong. I'm so happy and glad that we did this project. Others told the Oxford researcher that they felt the main value of AI imagery was that it assists those individuals with lived experience that felt they couldn't create visual art or they couldn't articulate their experiences in words to tell their stories. So just to finish up, it was obvious to us that in a particular environment where images were banned, the evidence shows that this project really did help participants process the trauma of their experience and feel empowered in telling their story. So generative AI proved to be a tool that enlivened our clients' testimony and allowed new audiences to see and understand what happened. So for us, the project had a longevity that we had not initially expected. It continues to open conversations around Australia's treatment of refugees internationally and domestically. This project did happen in a unique context, but we think there's clear learnings for other practitioners in how to use AI to share client stories. And just to end, there was one quote that really stood out to me that a woman told me on the phone after we'd been through this whole process together. And she said, "I just want to say that I'm so proud of myself that I could fight back and achieve justice by telling my story through this project." Thank you.
Thank you. Our next speaker is Lauren Sudeall. Lauren holds the David Daniels Allen Distinguished Chair of Law at Vanderbilt Law School, where she also serves as director of the Vanderbilt Access to Justice Initiative. Her research focuses on access to the courts, both civil and criminal, and how lower income individuals engage with the legal system, either with a lawyer or on their own. The floor is yours.
I'm going to stay here if that's, I'm slide free today, so I will stay here. And that's just a phenomenal project. So thank you for doing it and for sharing it. It's hard to follow that with ideas that I have. Okay, so a lot of my work in recent years has been empirical in nature, really trying to sort of shed light on what's happening on the ground. So this project, I think, steps back a little bit, and it's informed in large part by work I've been doing on a project with the American Law Institute that's focused on high volume civil adjudication. So really thinking about how courts operate in structural reform. And this is a very, very early stage idea, but I think it's really great to be presenting it here, in part to hopefully get ideas from folks in other jurisdictions, other parts of the world that may approach this issue differently. So there's two main premises of the project. One is, in recent years, some of the focus in access to justice reform has shifted from primarily providing additional supply side resources, so things like lawyers, justice workers, or other forms of external assistance, to also thinking about demand side reform, right? How might courts adapt or evolve or be restructured to incorporate assistance into the institution itself and maybe reduce the need for external assistance? So things like simplification, active judging, other sort of court-focused mechanisms. And in thinking through some of these reforms, it's occurred to me in multiple instances, whether in shifting the onus for reform onto courts, do we lose something in terms of litigant autonomy or agency? Is there a lurking danger of paternalism, sort of how we're approaching this, or are we sacrificing individuals' ability to really shape their own justice-seeking process? And that brings me to two, which is, and this has come up in the project, but I think more broadly in thinking about reforms, when we evaluate or assess reforms, we often think about things like accuracy, right? Fairness, sometimes efficiency, or some folks value that. But absent from that list, to me, it feels like something about this essence of agency or self-determination, right? That doesn't really seem to surface independently. The idea that a person navigating the system should really have the ability to drive this process. And I know there's a lot of overlap here with procedural justice, and I'm still sort of working on, right, to your point about distinguishing terms, right, how this is different. But obviously procedural justice emphasizes the importance of individual voice and ensuring that people are heard, treated with respect. I feel like there's something different here, right? In some of that literature, at least, the focus still seems to be on what the court can do to facilitate that. It's not sort of housed in the individual and sort of a right or an interest of the individual. So I'm still fleshing that out, but I think it relates to a lot of what we've been talking about so far today, right? This idea of legal capability, in part, could be used to effectuate this interest. So the problem, as I'm framing it, is that the more courts assume an active role in the dispute resolution process, and the more decisions that are typically made by litigants are instead managed or driven by courts, the less autonomy litigants may have in choosing how to direct and ultimately resolve their own cases. And I don't think in thinking about structural reform, these two things have to be mutually exclusive, but it may shift right where courts are focusing their energy. So one path for reconciliation might involve the court taking a more active role in informing litigants about the requirements and range of possibilities available, but still leaving the ultimate decisional responsibility with the individual. So just one more concrete example, at least where this has come up for me, is in the context of settlement. Right? So I think settlement is an area where you might be concerned both about the exploitation and vulnerability of unrepresented litigants, but also their ability to preserve autonomy and sort of how they want this issue to be resolved. And I think the underlying concern here is that there are powerful repeat players who often themselves do have lawyers who might take advantage of unwitting defendants. So one traditional solution might be provide these folks with lawyers or with other types of assistance, maybe even forms of self-help assistance. A demand side solution might be to adapt court processes so that courts play a larger role in ensuring that these settlements are fair and accurate, right? So that might, in a more extreme way, even allow courts to review and maybe even reject these settlement agreements if they don't seem fair. I think another take on that is that a more empowering and alternative might be to focus efforts on ensuring that the settlement is knowing and voluntary, and instead arm litigants up front with an accurate understanding of the law. So the court can assist, but still really leaves that onus on the individual to decide whether to accept the agreement. So you might see this as sort of an arc, right, from the sort of older status quo of relies on proactive individualism, which is flawed for a lot of different ways, right, in part because a lot of folks don't have support, to maybe shift away from the individual on this acknowledgement that people don't have support. And so we need to place this in the courts. And I think this sort of tries to maybe bring things back a little bit, but was to still empower the individual while ensuring that they have what they need. So in terms of what's currently recognized, and I'm curious to hear what others can share in terms of feedback, at least looking at the US system, in terms of just thinking about how this concept is discussed, it mostly comes up, perhaps unsurprisingly, in the context of thinking about lawyers. So the two places that this comes up is in thinking about the individual's autonomy vis-a-vis their lawyer. So if they're in a lawyer-client relationship, what is their sort of ability to drive the litigation, or if there's conflict between lawyer and client, right? Where does the client's view get to win out? There doesn't seem to be, and the other area where you see it is also an individual's ability to refuse a lawyer, right? To refuse to have a lawyer forced upon them. But all the discussion is very lawyer-centric. It seems that courts have been either dismissive of or maybe just blind to the notion of unrepresented litigant agency, the idea that somebody without a lawyer might still have some sense of agency or autonomy in driving their own justice process. The one area where this does seem to come up more is in the context of mediation. And again, I'm pretty early on in sort of thinking and delving into the literature here. But, one point that I meant to make about all that is even where the case law does sort of give that right to the individual, it's often limited, in part because it still comes from the Sixth Amendment. And so even in other contexts, like on appeal, where the Sixth Amendment doesn't apply, people even don't have that same right. Right? In those instances, the government's interest in the efficient administration of justice might still outweigh the individual's autonomy interest. So even though there is this interest that has been recognized in the lawyer context, it's still somewhat cabined. And I think where litigants are not entitled to counsel, the court seems more concerned about the underlying fairness of the proceeding and less about the litigant's ability to exercise agency. That doesn't really seem to be present in the rules and the case law and whatnot. And I think there are reasons for that, but we probably don't have time to discuss that in 8 minutes. Okay, so the model standards for mediation provide that self-determination is the act of coming to a voluntary, uncoerced decision in which each party makes free and informed choices as to process and outcome. So, in looking a little bit into the literature on mediation, I find it interesting that it was originally adopted as a means to allow people to exercise meaningful self-determination. And in that literature, there is some discussion of procedural justice, right, and how there is some overlap here. But again, I think it's a little bit different. And even there, Nancy Welsh, who's written a lot about this, has written about the thinning nature of self-determination, even in that context. So in the original view, the mediator's role was to enable the party's will to emerge and thus support their exercise of self-determination. And yet she wrote in 2001 that disputing parties had begun to play less of a central role, operating more as consumers limited to selecting from among the settlement options that are developed by their attorneys. So even in that context, which originally was so grounded in this idea of self-determination, it seems like that has fallen out a little bit. So I'm just curious to think about, right, how we might try to sort of recognize this, maybe not necessarily as a, constitutionally grounded right, but as some sort of interest that's that comes into this realm of how we both think about reform and how we assess reform. And I think at least as I play this out, then one role this could play is not just in encouraging courts to adopt structures that facilitate procedural justice, but it might also serve on a check on courts, right, in certain reforms. I think if we actually view this as an interest that's inherent in the individual, it might serve not just that sort of affirmative role, but also a protective role as well. And I think at the very least, I would like in these discussions to acknowledge that we're making a trade-off, right? Maybe at the end of the day, it makes more sense to ask the courts to do some of these things. And I think it probably varies by nature, right? In the last panel, we talked about determinations of eligibility. It might be that that doesn't really infringe on the individual's self-determination interest in a way that other decisions might. But I think just having that as part of the discussion as one of the interests or values that we're talking about would be valuable. And I'll end there. So perfect.
Thank you. So next up, we have Ab Currie. Ab is a senior research fellow at the Canadian Forum on Civil Justice, where he's mainly involved in research on various topics related to the everyday legal problems experienced by the public. He's also conducting research with community legal clinics, and he has conducted extensive research on access to justice in Canada for more than 3 decades now. So the floor is yours.
I'm going to talk about building structures of accessibility as an aspect of people-centered justice. And it's based on my experience monitoring a mobile outreach, rural outreach project in Wellington County, rural Wellington County, which is about 50 or 70 kilometers west of where we are right now. It involved 2 community legal clinics, the legal clinic of Guelph in Wellington County and Halton Community Legal Services. I think this is an important aspect of people-centered justice because it's this building structures of accessibility, because it focuses on people who don't come to clinics looking for help. And we know that's a huge problem. Now, rural Wellington County was an advice desert. We knew that from intake data. People were coming to the clinic from the cities, but they weren't coming from the rural areas. There had to be some way to go out and get them, because in a sense, if you think about people-centered justice is taking into account the way people behave when they experience a legal problem, this is how they behave. They may do all kinds of things to try to resolve the problem, but they don't seek authoritative help. And I mean, essentially, that was the problem that linked with the advice desert idea. Now I should tell you a little bit about the project. Here's a picture of our lovely little van. It was a mobile, in the summer, a mobile van went round to small towns in the community, in the rural area, parked in a high visibility place in each little town, erected a marquee tent, put a sign out on the side of the road, free legal help. And we waited to see what happened. In the winter, there were in-house, what do I want to think of? In-house satellite locations located in libraries and in the what am I trying to think of? In the premises of various social services agencies and so on. So that's really quickly what happened. How did it work? Well, this slide shows you the number of people who came summer and winter. And about 500 people in the summer came. It sort of evened out to that. In the winter, in the winter venues, it started out slow, but it ended up to be about 300 people. So that's about 800 people coming every year. There's an interesting kind of slide about about the people coming. At the beginning, about 85% had no previous connection with the clinic. As time went along, that percentage decreased, as you would expect, because the project built a presence in the area. Now, I don't know whether people were not coming because of the rural factor, or whether there were a whole lot of other behavioral factors that were, barriers. And I should say, I didn't start out, when I was beginning to monitor this project, I didn't start out to examine any hypotheses or any ideas about people-centered justice. This just sort of came to me as I monitored the project. So a lot of people were coming. I think they were coming seeking advice, seeking authoritative advice for the first time. At least a lot of people were. This gives you an idea of the problems that people came with. The interesting thing for me is that about a half a dozen problems made up 75% of all the problems that people came with. It would be odd if that were not the case. I mean, that's typical. But about 25% of the problems that people came with were all over the map. Elder abuse, identity theft, all sorts of things. This was a completely open, completely accessible project in which people felt, people felt comfortable coming with any problem that affected them. So I got thinking, okay, this is really people-centered. This is really opening itself to people in ways that is attracting people that had not come before. Now, when you have a project like this, particularly run by small clinics, practically run by anybody, I think, any legal services, I think, you can't do everything. People come with such a variety of problems that you're kind of limited in terms of for both financial resources and expertise in dealing with the variety of things that people come with. So the most of the services were referrals, and I mean that was an interesting part of the building the people-centeredness and the sort of structures of accessibility, is building this network of referrals that you really needed. Most of the referrals were legal. But if you look at, at the first referrals, 10% of the referrals were community groups. For second referrals, 30% were to community groups. Third referrals, 50% were to community groups. So what the project ended up doing was, in terms of building, again, structures of accessibility, was building partnerships with community organizations, and building partnerships in which the community organizations were already helping people, and the clinic assisted them with the legal aspects, and took referrals from them, from for people who had legal aspects of otherwise complex sets of legal and non-legal problems. So I've written all sorts of papers, not all sorts, three or four papers on this project. If you're interested in this kind of thing, you can find them on our website. But again, I'll repeat myself. I think that what I began to understand, among all the things that people-centered justice can mean, building structures of accessibility that take into account how people are behaving when they confront problems. That's people-centered. Thank you.
Thank you. And last but not least, we have one of our conference organizers, Dean Trevor Farrow. Trevor, in addition to co-organizing the conference, is Dean of Osgoode Hall Law School and is internationally recognized as a leading scholar on access to justice, legal process, and the profession. He's also consulted regularly, including as a research expert on the OECD's Advisory Justice Research Consortium. And his list of awards is too long for me to mention, but he's also an award-winning professor and writer. So the floor is yours.
Thank you so much. Great to be with everyone. My project that I'm going to talk about today briefly is called Measuring the Impacts of Legal Services. And it's a project that I'm still doing with my colleague Currie and Lisa Moore and our colleagues at the Canadian Forum on Civil Justice and the Institute for Social Research. My goal today is to try and get a bit of feedback and advice from folks here, because I think it's a story of some success. I think it's a story of total promise. I'm really psyched about this project. And it's also today a bit of a story of failure. And I want to focus on the failure piece because I could use to fix that. It's kind of our goal. So we're thinking about people-centered justice from a researcher's perspective. What we're trying to think now of is people-centered research. How do we do people-centered research that we can then measure this stuff? This project is part of a trajectory of research that I've been involved in. I've been involved with AB. Actually, I'm going to give a shout out to Diana Lowe, who's over in the corner with who started the Canadian Forum on Civil Justice. Numbers of people have been doing this stuff, so I'm certainly not alone. But the idea, from my perspective, was more than 10 years ago, did a study on trying to think empirically about what does it mean for people, what is access to justice, then moving towards legal needs and joining the worldwide group of legal needs studies, then trying to get into the idea of, so what does it cost people if we deliver and don't deliver justice? We did some of that work. Then trying to move the dial forward on the idea of return on investment. That must do it. You know, like if we can show that that's a positive return on investment, we've done some of that work. And now I think where I'm at anyway is the next stage for me, and at least in my own thinking of, is like, if this is about justice, if it's about getting people some notion of the good life, how do we actually establish that we are improving their lives with this stuff, with the tools of justice? So that's what I'm interested in. And it's sort of stealing from the medical world when you think about, does it help people if you give them Tylenol versus ibuprofen or some intervention or what have you? Like, are we doing anything here and does it make a difference? We think we are. Lots of anecdotal stuff. So that was the idea. So what we set out to do was do a longitudinal study, work with vulnerable clients in the legal aid clinic settings. We got Law Foundation of Ontario funding, shout out to the LFO, 2 sets. One was to develop a small grant to develop a methodology and a network. Secondly, to actually roll it out. Then, of course, the pandemic hit, so that was challenge number 1, but I'll put that aside. As it turns out, we ended up focusing, we were hoping to triangulate with 2 or 3 clinics to scale up our population size and study this. For various reasons I won't get into, we actually ended up being with 1 clinic. So it's a community legal aid service program. It's a program out of, it's one of our Osgoode poverty law clinics. And it was, so we did it through there. The idea was to ask people at point of service, what did you receive? And most importantly, how did it impact your life? I'm summarizing. And then essentially 3 to 6 months later, and we shortened that, come back to them and say, so now that you've had time to reflect on this and live your life, what was the impact of having received this service in your life? Effect on finances, relationships, safety in your home, keeping your house, that kind of stuff. And so that's what we did. And I think it's a great project. We have some success. We've literally just got the data. I was hoping to have the report written for this week. It's going to come out, but we're not quite there yet. And And I can focus on the stuff we're finding was really interesting, but I can leave that for later. And I can sort of, spoiler alert, there were positive impacts on people's lives. But I want to focus on the challenge that we had, because this is the struggle. So small population. We started with a clinic that is really busy, that doesn't have time for this. So we picked a student clinic. We basically used free labor by the students, essentially taught them how to do this stuff. And then they were the ones, because they're interfacing with the clients at the time with the service lawyers to do this. So challenge number one, getting busy clinics to do research is kind of unfair. And so you have to empower places to actually have the space to do it. Challenge number two, other than ethics approval, is how do you empower the people who are involved to get their voices? And so it took us, Ab and I and Lisa and others, like we spent months going back and forth with our questions, how we were going to do it. And we moved largely from a very closed-ended question to a much more essentially structured interview, open-ended. Pluses and minuses. We've got great stuff coming back, but there's challenges. So we had essentially about 100 clients that we had approval to do. 26 actually agreed to do the first point of service interview. And as it turns out, over the course of all of this, what we were successful in getting back was 10 follow-up interviews. So there's failure number one, or challenge number one, is just tiny population size for what we tried to do, bit of a pilot, if you will. So I'm certainly not claiming that we have this massive database of answers, because we don't. Second challenge, of course, is comparing apples and apples, because you pick a clinic that does a certain kind of work, like disability services, immigration, landlord-tenant, and then you can even limit it into the same kind of service. So you can sort of narrow it into trying to compare apples and apples. But of course, people's lives are different. So criticism number two might be, well, how do you compare one client versus another, their experiences, even in an ODSP, a disability services hearing, because their lives are so different. So does that matter or not? Problem number three, we did not set out to do randomized control groups. So this was not, if you give it to one person and you don't give it to another, the placebo thing. We can then say, well, if you did get it, we're not doing that. For ethics approval, practicalities, and we just didn't do that. I actually think that's okay. And I think the RCT literature it's not that it's bad, of course it's great, but it's not the only thing. So you can find out stuff, even if you're not comparing it to other things, but that's a challenge. So how do we do that? And then the type of questions we asked, pointed versus open-ended, because the data that we're getting is not all over the map, but it's in people's words, right? So it's very people-centered data. And so what we're going to need to do is find a way, as we tell this story in good faith, to categorize, to sort of show for readers in punchy slides and stuff what they're actually saying. And so do we as a research community care more about the ability to do a Likert scale or graphs to be able to say this was the financial impact by dollars and cents, and getting that qualitative, this is how it impacted me, this is what happened to my daughter's safety and whatever, and getting those stories. So it's a bit of a challenge. At the end of the day, what I really want to do now is show what we've learned, still learning, the positives of what we can do, and then totally scale this up, because I think there's lots of willing partners who would like to do this. And if we can roll this out over a longer period of time across the city, the province, maybe the country, with lots of willing partners, that's when I think we'll be able to triangulate and show some real stories about the impact of, are we helping people to improve their lives? That's the story.
Thank you. So now we have about 15 minutes for questions. There is a microphone in the room. So please, go ahead.
Question for Ab. So I'm from Australia. One of the things I do is work with my regional community legal centre. Really interested to hear more about your service. Who were you seeing in those kind of face-to-face pieces of work you were doing? Was it different kinds of people or different parts of the community than people who were, say, coming to you? I'm just interested in any reflections on who used the service that you didn't see coming through your doors normally.
Well, I wasn't able, I relied mainly on data that we were able to capture in this holistic intake process. So we couldn't capture very much data. But what I do know is that in terms of who was coming, I guess one major thing, the vast majority of people were disadvantaged. And they were either unemployed, on social services, you know, a variety of situations like that. Yes, I'm quite certain that about 70% of people were, you know, could be considered by some criterion or other disadvantaged. 30, about 30% were employed, self-employed, whatever. Otherwise, we did not collect a lot of data, you know, personal data at intake, because you just in a free flowing process like that, you just can't do it, right? So what the you know, the people at the van and at the winter venues had to do was develop the capacity to, you know, as they, you know, they started to chat with people, you know, why did you come? What made you come here? Do you live here? No, I don't live here. How far away do you live? And, you know, and through that kind of conversational process that they tried to be more or less consistent with, they would record data. And essentially that's, we did do a small follow-up survey of about 30 people, asking people, you know, how they valued the service, the degree to which they considered the service part of the community, you know, questions like that. Yeah, so that's does that answer your question, or can I? Yeah.
Yes, back there. Yeah, I can.
This has been a really fascinating panel and a great panel. My curiosity, I guess, I'm just picking up on a phrase actually that you used, Dean, around we don't have time to do this. That idea of measurement perhaps being the other side of person-centered service delivery that we don't always manage to get a handle on. That if we're actually truly doing person-centered justice or person-centered delivery, then perhaps we shouldn't be the ones assessing what those successful outcomes are, that we should be having person-centered outcomes and measures and actually asking people. And I think it's fantastic to start in a research project to start to ask people what it is that you wanted to achieve. And I guess I wonder around, though, if we're thinking about ways to do that, thinking about how we integrate that actually into program delivery, that actually perhaps it's not good enough to say that we don't have time to do this, because how do you actually know you're successful at what you're doing if it's person-centered, if you don't actually ask people, am I achieving what you wanted me to achieve for you? And that idea of change in that respect. So rather than perhaps comparing justice outcomes for people where we say, is that a good outcome? Is that a bad outcome? That we're actually looking at how the people themselves assess change in their lives. I was desperate and in a crisis in relation to this issue, and in 6 months' time, I feel significantly more confident. So if we want Likert scales, but thinking about how we make those person-centered, in that the person has seen a trajectory in their own lives and we can measure that. And then it doesn't really matter what the outcome is. It's more what they came to achieve and what we ended up being, they felt they were able to achieve because of the experience. So probably more a comment than anything else, but thank you.
Any reaction?
Another way that I collected collected data was asking the people at the winter and summer venues to record volunteered, unsolicited remarks. And that was probably among the most valuable bits of data that we collected, although it wasn't systematic by any means. Can I give you one example?
Sure. Yeah.
Two women, two Aboriginal women came to the van, and each of them had a variety of problems. I can't remember the exact problems now, but you know, they had a number of problems, and they you know, they got some direct advice on a couple of them, got a lot of referrals, and at the end of this process, one of the ladies said, you know, we've been here for such a short period of time. Do you have any idea how much you've helped us? You know, and when you engage people like we tried to do, that's the kind of outcome you get. And I don't know, you know, I did a little bit of follow-up asking people if they, you know, how they felt about the service as a part of their community. And people said things like, well, we're really pleased that this is available close at hand in our community, available when we need it. But I didn't get I wasn't able to do anything like in terms of any long-term follow-up. But I know from the unsolicited comments that people found it immensely valuable. And anyone who's doing this kind of research, if you have an opportunity to collect data like that, don't miss it. And it's really worth it.
Thanks. Trevor, did you want to? Oh, yeah, no, go ahead. Yeah. Nicki, do you want?
Hi. Oh,
Oh,
sorry.
yeah, no,
I thought you said-
one reaction perhaps, and then another question. Yeah.
Just going to make a quick comment to the question before. I think two quick reflections. One, in terms of taking feedback from people with lived experience or the people that are centered within the project. With the Exhibit AI context, you know, there were some really difficult moments for us where the feedback from the advisory group was not what we thought was best. And it was this really tough situation where, okay, we're putting this out to the world, but who are we doing justice to in this project? And in the end, we had to go with what the people wanted, even though it was against our gut reaction as lawyers, you know, very like professional glean on things. And that was a real learning for us, actually, that we can have all the best endeavors in the world, but it's who are you going to listen to in terms of feedback? Another really quick reflection, I think it's just your comment around failure. I think it's so important to acknowledge when things don't work and not feel precious about projects that you do and take that feedback. I set up a project in some prisons, and I thought I'd created the best project in the world, and absolutely no one turned up. And I was like, okay, this is not good. And I sat down with 150 young Aboriginal men over 6 months, and they told me why my project was bad. And then we created what I think is a really good project out of that. But it took that process of not being precious and actually having that consultation.
Thanks.
I have a pretty simple question actually about the mobile outreach. How was it funded? How much did it cost? And do you have sustained funding to carry it on over time?
I can't tell you for sure how much it costs.
Okay.
We did not have, the project was sustainable by every measure that I could think of, like in terms of community support and all that sort of thing. But when the funding, you know, this is what I call the Cinderella effect, right? I mean, the funding, you get reasonably well funded for a project. It works. It's kind of celebrated, you know, and then you know, at the stroke of midnight, you know, Cinderella gets shuffled back into the scullery. And I mean, this is what happens typically with projects. They work really well. The funding ends, and then the what is it now? 4 projects that I've worked on over the last 10 years. The clinics kind of struggle to integrate what works into their existing delivery model, but they do it at a much lower level. And you know, projects are not sustainable. Often they're not sustainable because the structure, there's no continuity in the structure of funding, no continuity between innovation funding and core funding. And that's something that I think, you know, is a discussion that's worth having among, well, in Ontario, Legal Aid Ontario, which is the funder of the community legal clinic system, and all the donor organizations that sometimes that often very generously fund projects, but They don't connect.
So this project is over and not
The
funded?
project is over.
Okay.
The first and the second stage pilots are over. The project continues at a much lower scale.
Okay.
They're not visiting as many communities. They can't put as many people out in the field as they did, but it's still, it worked well. It's continuing, but it's serving far fewer people than it did during the pilot phase.
Okay, thank you.
Thank you. We have time for a few more questions if you want.
I mentioned while people are coming to the microphone, it seems like there's a lot of interest in the project for good reason. And there's a project, someone out there may know more. There was a project in California called the Justice Bus that used to be run by an organization called One Justice. I'm not sure, but that project has been going on for some time and I believe still exists. So if people want to sort of look at other models, that's out there as well.
Bonnie Huff, I don't know whether she's in this, she's around. She knows about that one.
Yeah. Go ahead.
Hi, Dr. Rychner. Something that struck me in your slides was, I can't remember, it was the highest area demand or one of the highest areas was around family violence inquiries. And actually, Belinda, in your previous panel, I noticed that in your slides as well. And it's something that I help oversee a project in Newfoundland and Labrador that supports survivors of intimate partner violence. And I find it's complicated because you're often dealing with parallel processes and family law, criminal law, sometimes protection orders and things like that. So I'm just curious, maybe for both of you too, but Dr. Rychner, like how that manifests, like what type of legal processes are you seeing come up and what interventions are helping? And is representation part of that is often a question I've been thinking of. Thank you.
Yeah, so I'll hand over to Belinda shortly because she's actually working on the front lines with this and I'm just doing research. But I suppose with family violence, it was one of the highest law areas that we received initiatives for. And there was just as much breadth in that category as there was overall. So some that come into my mind is lots were using sort of navigators or wayfinders within migrant communities that were sort of trained up or received legal education that could then assist women who might be at risk or experiencing. And there were other initiatives that would assist, that had legal practitioners assisting migrant women in filling out those forms because the forms for restraint orders and all of that can be quite complex and can be deterring, particularly for people with sort of migrant backgrounds. So yeah, very varied, and we hope to explore that further in the report. But I don't know if Belinda, you wanted to elaborate on what Eastern does.
Sure, thank you for your question. I don't know if this is right, I'm just completely surmising, but in Victoria, Victoria, Australia, we are very proud to have probably the most progressive family violence reform system, at least in Australia, and we'd like to think the world because it's the way Victorians are. And as a result, speak for yourself, says Lynn. No, she knows. But and that might be why also our statistics have reflected such an uptake in family violence sort of help seeking. And so in terms of your question about like the areas of law that intersect with family violence, maybe all of the areas of law intersect with family violence. That's certainly something that my legal centre sees. Every single area has some sort of intersection with family violence. Therefore, at least, the centre that I work with has the interventions that I guess we have been looking at is really incorporating what we're calling integrated practice work. So we have our community lawyers integrated with social workers, integrated with family violence advocates who may or may not be social workers, client advocates as well. And we also partner very, very closely and, we hold those partnerships very dear to us with our family violence specialist services, but actually also our health organisations and with our education providers as well, to continuously try and either for want of a better term, capture people earlier in their experience of family violence so that it doesn't reach the crisis point when they are engaging through the legal system. Yeah.
And in terms of community legal centres, a lot of them were working in schools to start that education early and through all types of, all forms. So using sport to communicate to young people, using plays. So yeah, really interesting work and important work being done.
Thank you. I think our time's up, unfortunately, but I'm sure the discussions will continue in the hallways in the next few days. So thank you for being here for this panel. Thank you to our panelists once again, and we'll see you later.